523A8 is the section that accepts student loans from discharge. And this is probably the most important slide we're going to cover today. And these are all the categories of student loans that are protected, or the types of debts that are protected from discharge. So basically, this section is saying, unless you can demonstrate undue hardship, if you have any of these types of loans, they will not be discharged in your bankruptcy. So the first one is any loan made by a government or nonprofit. So if you're talking about a federal loan, a loan made by, some of these nonprofit institutions, including some of the higher learning institutions. So if it's associated at all with a government or nonprofit, if it's funded in whole or in part by a government or nonprofit, then it would be accepted from discharge. The next category is the obligation to repay funds received as an educational benefit, scholarship, or stipend. And this becomes a sticking point in many of the cases involving private loans, because it's a question, the question becomes, what does the court recognize as an educational benefit? In some of these recent cases, the court recognizes that a loan is not what Congress had in mind when they drafted this provision for educational benefit. And the last one is for private loans, basically any other loan that is a qualified education loan, but it has to be under that definition of what the Internal Revenue Code recognizes as a as a private student loan. And we'll get into details, a little bit further details on that. Pardon me, 1 second, sorry. So let's talk about the legislative intent of 523A8. It's really to prevent undeserving debtors from abusing the educational loan program by declaring bankruptcy immediately after graduating. And then it's to preserve the financial integrity of the student loan program. I mean, they had good intentions when they drafted this initially, but since the student loan program has gotten so out of hand, tuition has risen over the last 20, 30 years. So it really doesn't, make as much sense as it did when it was originally drafted. So let's look at the like a side-by-side comparison of a federal loan versus a private student loan. So federal student loans are guaranteed by the US Department of Education. There are usually flexible repayment options. There's loan forgiveness available. There are various types of loan forgiveness programs, including the public service loan forgiveness program. But on the flip side, as long, you have the forgiveness, you have a lot of forbearance and deferment time, but if you do default, there are some serious consequences. The federal government can garnish your wages without a court order. They can seize tax refund money. They can garnish federal benefits. So definitely, if your client is in default on a federal student loan, it's, important to try to get them out of default, as soon as you can. Also, it's important to note that there's no statute of limitations on federal student loans. So that means, forever, like the person could be out of school 30, 40 years, they could be collecting their Social Security, and that loan will still be good, and that debt will still be valid. Private student loans, you would, of course, look to the promissory note to see the terms. They usually have much higher interest rates, usually above 10%. There are statute of limitations involved depending on which state you live in. It could be as little as 3 years or as long as 6 or 7 years. It's 6 years in New York and New Jersey. But you can easily look up in your state what the statute of limitations is for private student loans or for any private debt really. For private student loans, you generally don't see any forgiveness programs, no income-driven repayment programs. It's sort of like, this is what the monthly payment is. You pay it or else you're delinquent or in default. And the problem with many private student loans, I mean, honestly, like 9 times out of 10, you're going to see a cosigner. So that poses extra problems. So, when there's a cosigner involved, sometimes, you want to go to Chapter 13 route just to help them manage the loan without involving the cosigner. The cosigner would get the benefit of the automatic stay. And we'll talk about a little bit more about what it means if you co-sign a loan for someone who's not your spouse or dependent. That may mean it's automatically dischargeable if it's a private student loan. Okay, so how do you figure out if a loan is federal or private? You would have to pull the loan transcript from studentaid.gov. So you would direct your client to create an FSA ID, log into their account, and they're able to pull the transcript, which shows all of their loan information. So it's going to have, what the balances are, the disbursement dates, the interest rates, the status of the loan, all of their information about their federal student loans will be on that transcript. Now, then you pull the credit report. So once you do a side-by-side comparison of the federal student aid report and the credit report, you'll see that whatever's on the credit report that's not on the studentaid.gov report will be designated, that will be a private loan, because all of the federal loans will automatically be in that transcript from the Department of Education. Okay, so when you're discussing student loans, you have to litigate it. It's not just a matter of an administrative proceeding the way you would do a normal bankruptcy. You have to file what's called an adversary proceeding. So in that instance, the debtor is the plaintiff, and then they're suing all of the holders of their student loan debt. So if you're only litigating the private debt, you would do the research and figure out who holds all of the person's private debt. And, and it's important to note, if you are a bankruptcy attorney, that initially you were telling clients that there's nothing they could do about their student loans, but you realize that you have many clients that you could look back into their files and see that they have a substantial amount of student loan debt. Under the bankruptcy code, you can reopen a case at any time. So you can reopen the case, or you could file a new one depending on how old the case is, but it's easy to reopen a case. You file a motion and you can file an adversary proceeding after the judge has signed the order to reopen the case. I do have some sample pleadings in the supplemental materials. So if you guys need sample motions to reopen, you'll see that in the supplements. So when you're drafting the pleadings, like I mentioned, it's important to identify the right creditor. So you have to identify the defendants correctly. So remember that you are suing the lender or the holder of the note, not the servicer or the collections agency. So it's important to get to the bottom of that before you draft the pleadings and come up with your caption and who you're naming as a party to the lawsuit. And this is also the website to search the National Student Loan Database. You can use this link or studentaid.gov. Well, your client, you shouldn't really be accessing your client's FSA information. You should always have them log in and pull that information and then supply it to you. And like I said, the private student loan information will be on the credit report.